Hello, this is Matt on the Moon Family Sedan channel. An attorney within the XRP community thinks that settlement in the SEC v. Ripple case is actually more likely than not, which I don't mind hearing at all, frankly. And part of it may come down to, frankly, the Hinman emails. So yes, as you well know, the Billy Boy Hinman Ethereum Free Pass emails associated with that speech and the drafts, they're in Ripple's hands, but Ripple is not allowed to hand that information over. So you might think, well, it's already out, which means that the SEC doesn't care. Not so fast. Ripple CEO Brad Garlinghouse has already stated that the information within these documents are shocking. The court already determined that it must be handed over. So it's not that surprising in that sense that they comply because, frankly, there's still something that the SEC can do to make sure that those Hinman emails don't get out. And if it's just Ripple that knows them, fine. If it's damning, it's damning. And we don't know for sure exactly what's in there because the public hasn't seen them. If it's damning, it's damning. And Brad Garlinghouse and other execs at Ripple know. Well, I think the SEC's attitude is so what? They can't do anything with it, right? Not legally anyway. So there's a path forward for the SEC to make sure that that doesn't get out. I found an attorney on interwebs, specifically Twitters, that that says that he thinks that the SEC is going to defeat Ripple, and this individual, he is like his area of practice as an attorney is in securities, and other than him specifically calling out John Deaton by name, I don't feel like he was being rude or trolly or anything like that. And it is so hard to find attorneys outside of the SEC that believe that Ripple's going to lose, that when I come across them, I am happy to highlight their arguments. And I'm going to do that in this video. And also, there's an idea posited about this individual debating attorney John Deaton. And from what I've seen, it looks like he kind of walked away from that a bit. He just kind of wants to typey on the internet. It is what it is, though. But before going further, I do want to be clear, I do not have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything that I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. And here you go. So let's start with this. The Mr. Whale Twitter account tweeted out the following. Just in. Ripple and SEC settlement deal is a real possibility, says renowned lawyer and crypto enthusiast Bill Morgan. And then somebody responded and asked, is this true? And Bill Morgan responded and said, about being a renowned lawyer, no. Oh, you modest Bill Morgan. And then he says, about settlement being possible in the sense of a real possibility, I say yes, more likely than not. Which I don't mind seeing, and I can totally buy that. There may very well be secret settlement talks occurring right now, and we would have no way of knowing that. So let's go a little bit on further, though, and unpack why. So there is a tweet from the official library account. You may recall that regarding the SEC v. Library case. The SEC had a major victory defeating Library. I think it was a bad ruling. I've covered it in full, so not to rehash that in this video. But the Library Twitter account just a couple days ago wrote, we also requested to have all of our settlement discussions with the SEC recorded for transparency in the industry, which the SEC refused. And at that point, Patrick Riley, who is the CEO of Reaper Financial, who filed an amicus brief, and also note, by the way, XRP community member and attorney Fred Rispoli actually drafted that amicus brief for Patrick Riley. Patrick Riley wrote the following. That which is done in secret is unaccountable, and those who are unaccountable will always become corrupt. And so, look, I'll say this in a general sense. Yes, I prefer to have more transparency than not. When it comes to stuff like that, I'm not surprised in the least that it wasn't going to happen. I'll just say that. And here was attorney Bill Morgan's take on this. He said, settlement discussions are confidential for a reason. There's a public policy behind the confidentiality been maintained to encourage the type of open discussions you need to reach settlement and encourage efficient resolution of litigation. Yeah, and so I can understand that if it's just, I mean, it is a matter of fact. If you know that you're on the record I mean, what are you going to put out on the table if you know that you're under a microscope? So I can see the argument. Now, that doesn't mean that I think that there's sufficient transparency regarding what's happening in the SEC just in a general sense. But when it comes to those types of things and settlement talks, I think I find that persuasive from attorney Bill Morgan. And then and a community member named Adrian responded and wrote, "This means Ripple and SEC can agree upon the settlement at any time?" Question mark. And attorney Bill Morgan said, "Exactly. And nobody outside the parties will know until the parties say it has settled." So that's actually kind of a fun and interesting thought. And we could actually just wake up one day and bam, there's the headlines. SEC and Ripple have settled. Now, of course, there's a couple things that are certain if that's occurred, just from that's my opinion anyway. I say certain from my perspective. XRP, there's going to be a path forward, or else Ripple won't agree to a settlement. So it's got to be able to be traded. It's got to have some sort of designation so that it's safe. And then the SEC is going to have to find a way to save face and make it look like they did something. So I assume that would be some sort of monetary penalty for Ripple. I don't know exactly what else, but something along those lines. That's what I would anticipate would be a couple major components of this should it occur. And it still is quite possible. And so then somebody in the community was asking, okay, well, what about the Bill Hinman emails? Effectively, he's asking that. You know, are we gonna see those emails regardless? Either way, if there's settlement or not settlement. And attorney Morgan said, excuse me, folks, not necessarily if keeping the Hinman documents confidential is a term of settlement. That is why having them gives Ripple real leverage in settlement negotiations. Yeah. So the fact that the SEC has handed, well, they're court ordered though, so they had to do this. The fact that they handed over the Bill Hinman emails, look, I believe Brad Garlinghouse when he says there's damning stuff in there, but you know, it's also not going to play heavily in the SEC v. Ripple case anyway, frankly, in all probability, from what we've learned from attorney Deaton and other attorneys within the space. So in that sense, they probably wouldn't care about it from that perspective as much. It's more about just to, makes this look bad, makes this look slimy, because they know they are slimy. So they understand that they can still tap out here, and then the public, you know, you and I, you know, right here, we're never going to see it then. And then they can just settle the case. So from their perspective, handing it over, that's why I was saying, I don't think that it's that big of a concern for them. Now, do they want that information to get out? Are they really willing to do that? Well, they're putting on a show as if they are, but is that a negotiation tactic for settlement? You know, possibly. It could be as simple as that. Doesn't mean that settlements, you know, not going to happen. And then, and then Attorney Morgan also wrote this. In terms of like, when would there's a XP community member named Steve Marshall said, "Yes, Bill, when do the emails become available?" And Bill Morgan said the following: "We don't know on what basis Ripple received them. That does not allow them to be publicly revealed. Under the local rules under which I practice in Australia, there is an implied undertaking not to publicly reveal documents disclosed by another party until put into evidence. This is called a Harman undertaking, which derives its name from a 1983 English case, but has been more recently explained and applied by an Australian High Court case." And then he says, "You would need to ask Attorney Rispoli, Attorney Deaton, or Attorney Hogan if there is similar rule or principle that prevents Ripple publicly revealing the Hinman speech documents before they are put into evidence by Ripple." And then he tagged me there, so thank you very much, Attorney Morgan, for the tag. I do appreciate it. I find this topic very interesting. And luckily, Attorney Rispoli actually did respond, and he clarified, and he said, "The confidentiality order applies, essentially the same as the law you quoted. SEC designated emails confidential, and Ripple needs a court order to undo that designation. I expect them to be in the reply, but redacted, and will be part of argument to unredact full brief." So yeah, exactly. So Ripple's going to be pushing for this to be put out into the open, and we'll see what Judge Torres has to say about this. But you know, if this thing goes to like a jury trial, if that actually happened, like, yes, we'd see it then. You know, outside of that, are we going to see it? You know, if there's a summary judgment in favor of Ripple, probably. So that's why I'm saying, like, the only way out I know for sure is if the SEC chooses to settle. So it's like, how badly do they want out of this? And I don't know if they are. I still think it's a possibility. But there is an attorney named Gregory Frank, and this is the guy that I was citing at the outset of the video, who thinks Ripple's going to lose, thinks the SEC will win. And anytime I come across an attorney who has that perspective, happy to highlight them on the channel because it's very rare. And I'm actually, just to be clear, I'm not highlighting this just to like mock this guy or something like that. Like, to be honest, from what I'd seen, other than I kind of questioned the way in which he was kind of calling out Deaton, but other than that, it seemed like he was just sharing his honest perspective. I don't have any indication that he's biased. He just has an opinion that's kind of rare from what I've seen anyway. And he also thinks that the attorneys within the XRP community are leading people like you and me astray. He actually has cited that. So I'm going to share with you the specifics of why he's arguing what he's arguing here. You know, if he's operating in good faith, no beef whatsoever. If there's any indication, though, that he's biased against Ripple or XRP, if there's anything like that that comes up, I'm like, okay, well, there we go again. Because, you know, that's like, there are two other attorneys that I highlighted that outside of the SEC that were arguing the same thing as Gregory Frank. And then if you come to find out, well, for years leading up to that, even before the lawsuit, they had been hating on Ripple and XRP. So I'm like, okay, well, so if we find anything like that, then I'm not going to think that he's necessarily unbiased. You know, I don't think I would then think he's not coming in as a blank slate, but I don't have any evidence that he's anything other than being intellectually honest, which I appreciate. You know, I like thoughtful discourse, and he's not doing any trolly stuff or name calling from what I've seen anyway. And so here's what Securities attorney Gregory Frank wrote, which did end up catching the attention of Attorney Deaton, which I'll highlight in a minute here. But Attorney Frank wrote, "The reason SEC won in Library and will likely win in Ripple is the narrative on Gensler being a rogue agent is horse S-word. The cases win because they are conventionally good cases any head of SEC would bring. The defenses raised are novel and would not dissuade a new SEC chairman." As I was pausing to note, I don't know exactly what he's talking about there. I've been covering this case for almost 2 full years, very in depth. Look, there's all sorts of stuff, you know, brought up about impropriety surrounding various people at the highest levels of the SEC and questioning Gensler's motives and this or that. But like Gensler's motives or whatever he's doing or the narrative or, you know, how he's suing Kim Kardashian, like none of it has anything to do with whether or not we in the community, believe that, you know, Ripple's going to win the case. That's not what's being argued by attorneys within the case. Do you see Ripple's attorneys argue anything about Gensler in the case? Because I sure as hell don't see it. So I don't know what attorneys Frank is talking about right there. I think that he's mistaken. He may not be particularly well-versed on the case. He says that he's read I think he said he read the entire motion for summary judgment ultimately. Yeah, he did. I see that. I'll get to that, his comments on that in a second. But to what degree he's actually well-versed, I'm kind of questioning that because that's not in there. The stuff where they're complaining about Gensler is that, no, that's not their defense. And then as far as the defenses raised being novel, I don't know what he's talking about. I mean, if you're talking about, the nature of what XRP is, there are a number of things he could be referencing. If you're talking about the nature of XRP, well, I learned this because of Ripple's attorneys, and Attorney Deaton's talked about this, Attorney Hogan's talked about this. You know, the SEC v. Ripple case is being tried in the Second Circuit, and if you look at all of the case law in the Second Circuit, you know, there's no instance where there are found to be securities violations where there was no actual contract. Specifically, there was never any sort of violation to be found with something being traded on secondary markets. So the argument the SEC is bringing is novel, not the defense that Ripple is bringing. That's not novel. So I would disagree with Attorney Frank there. That doesn't seem to make sense to me. I know I'm not the attorney he is, but there are attorneys who are well-versed on this that say Attorney Frank is wrong here, and I find their statements to be more compelling, so I have my own opinion, even though I'm not an attorney. That's just how it works. So I don't know what he's talking about there, so I would just respectfully say I don't think that makes sense, but maybe he could flesh it out in a way where it would be compelling. I'm not seeing it, though. I read a bunch of stuff that he shared. I'm just sharing selections here for the sake of time here. And then he says, "It really isn't a logical or healthy fantasy to imagine replacing Gensler will change anything." Okay, let's pause here. Gensler may very well end up being replaced due to political wins. I'm not even talking about that. I barely even talk about that. I brought it up before. But as far as it being some sort of fantasy that I think would impact the SEC v. Ripple case, I'm not confident in that. Who's confident in that? I don't even know who he's referencing here. Where does he get the idea that the community, XRP community at large, thinks that's a thing that would happen? I mean, the community is gigantic, so I'm sure you could find some people. But is that something that on the whole we're like, we need to get a new SEC chair so that the SEC v. Ripple lawsuit goes away? Is anybody really, pounding on the desk for that? I'm not really seeing that. And then he also said, having read the summary judgment briefs, the SEC case has a very good case under current law. There are a bunch of fake crypto lawyers getting everyone's hopes up in the XRP army. It's cruel. So, I don't know. Maybe I'm giving this guy too much credit because he starts calling fake crypto lawyers, and then he later called out Deaton. Maybe I'm giving the guy too much credit. Maybe I should retract this. Maybe he is being a little snide. But, again, when you're talking about what XRP is just by the nature of it existing, like, what is this guy talking? Because let me back up. If Ripple loses, which I acknowledge is possible for sure. I've always acknowledged that. But if they lose, and it's just that they have to pay a penalty and they lose based on some certain early sales that the judge thinks satisfied the Howey test and all that jazz, and even though there's no written up contract, there's, by the nature of the scheme, it suffices, it counts as a contract. Okay, fine. If the judge finds that, okay, I only care to a certain degree. Not that much, to be honest with you. What I care about is what happens to XRP on a go-forward basis. So if he's talking about Ripple losing, but then XRP is still allowed, and the judge could declare that XRP explicitly is not a security, if we get that, then I'm going to call that a win. So then Attorney Frank could say, see, I was right, Ripple lost. And I'm going to be like, okay, but there was a huge win here for the XRP community. I don't care. And if Ripple has to pay a fine and then they can continue to conduct business and resume on-demand liquidity transactions, all that crap, I say that's a win then. That's fine. Even if it's a technical loss, in which case maybe I'd be persuaded to technically agree that that's possible. And I mean, I do agree that's technically possible, but that's not the biggest reason I'm here. I don't like seeing Ripple get attacked, but that's not the reason I'm here. I'm here because the entire crypto asset class is under attack. And if XRP is a security per se, just by the nature of it existing, we got a serious issue. And that's why I responded to Gregory Frank here, and I asked him, are oranges securities? Because, look, it's never the underlying asset that is the security. We know this. And he hasn't responded. And it's been, I don't know, coming up on 12 hours or something like that, I guess, at this point. And he hasn't responded, so I guess he's not going to. But it's not the underlying asset. So in terms of what a win would be to me, it's not so much about whether or not Ripple has a technical victory or not. It's more about what happens to XRP. If XRP is safe to me, that's a gigantic win. That's what I'm saying. And so then on that, Attorney Morgan wrote to Attorney Frank and said, you do realize that most of those lawyers have said certain offers or sales of XRP may be investment contracts, but have criticized the SEC's case for stretching the Howey test to argue there's one continuous offering of XRP that has lasted for 10 years, covering any sale of XRP by anyone, even in secondary markets. And this goes beyond in scope what the SEC has argued in any other crypto case. Yeah, and that is a very good point. If they were targeting specific transactions, that would be one thing, but they are stating that every single transaction that's currently occurring is also some sort of investment contract transaction. And so I suspect that Attorney Frank here, who thinks Ripple's going to lose, I don't think he's as informed as he's leading the public to believe that he is, because he's stating all these things, saying fake crypto lawyers. Like, does he even recognize that, attorneys within the XRP community have acknowledged that certain sales may be found by Judge Torres to be, haven't been illegal in terms of they're actually representative investment contracts? I mean, Attorney Deaton said that. Attorney Hogan said, they've all said that. So I don't know what he's talking about. That could happen. But again, in terms of what matters to us, is XRP itself a security? No. And I don't see how the SEC is going to get what they want in having XRP declared a security, because that would go against all case law dating back to 1946 when the Supreme Court took up the SEC v. Howey case. So, and then there was a tweet right here from somebody within the community who asked attorney Frank, "Are you willing to go one-on-one with John Deaton in terms of debate?" And attorney Frank responded and wrote, "As far as I know, attorney Deaton hasn't practiced a day of securities law in his life. According to his website, he specializes in asbestos litigation, products liability, toxic torts, and personal injury." So I'll pause and note, okay, that's quite technically true, and attorney Deaton has acknowledged that, and he's kind of acknowledged what he's doing in a funny way on more than one occasion. I've seen him in interviews. He's like, "Well, I've been a securities attorney for like a year and a half," because that's not what his focus was in terms of law. But so what? He's got involved. He's certainly done the homework, and he's certainly well informed here, and he's confident for a reason. And so attorney Deaton saw that, and he wrote the following: "Greg, I noticed you didn't answer the question, but instead chose to discuss my qualifications, or should I say, the lack thereof, regarding a civil and respectful debate/discussion. It sounds to me that since you are a real security/crypto lawyer, it would be an easy task." And then, so again, attorney Deaton's right. Attorney Frank was asked, "How about that debate?" And he just dodged the question and started talking about the credentials of attorney Deaton. Well, attorney Frank responded to Deaton and said, "Attorney Deaton, have you made an analysis of SEC summary judgment brief so I can respond directly on what I agree with and what I disagree with? I think it's a great idea to have a discourse on what we've learned from the briefs." Okay, but you did just call him basically a fake crypto attorney a lot, and it seems like you were probably thinking of him because you ended up tagging him after you had a separate tweet where you were talking about fake crypto lawyers, or however the hell you worded it. But here you are, again, attorney Frank, dodging the opportunity for debate. And also, if you're asking if John wrote anything up, that extra makes me think you don't know what you're talking about as it pertains to the specifics of this case, because anybody following the case would know that attorney Deaton did file an amicus brief, highly publicized, in fact. So methinks that attorney Frank is just has opinions that maybe he's gotten a little ahead of himself there, cart before the horse type of thing. So if there are any additional developments, I'll let you know here. I'm still optimistic. There could be a settlement. I don't know for sure. Even if there's not, even if Ripple loses on some fronts, doesn't mean that it's going to be bad for XRP. It might not necessarily be the end of the world. Judge Torres absolutely has the ability to declare specific things about XRP and from a legal perspective, how it would be treated on a go-forward basis. And we need a positive ruling on that. I think we'll get it because, again, if you just look at the case law dating back to 1946, as Ripple's attorneys have cited, as attorney Deaton has cited, as attorney Hogan, and so on and so forth have cited, like that's what law would have you. That's the conclusion that you would come to. That's the conclusion the case law would have you come to. I don't know how you wind up at anything else. So there's always a possibility for a bad ruling, but I'm optimistic. You let me know what you think in the comment section below, but I'm done for now. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the Moon Family Sedan.